May it please the court, Your Honor, I, Jason Cano, and my partner, Kevin Perez, will be addressing the resolve, is the race-conscious affirmative action consistent with the 14th Amendment to the United States Constitution? I will be addressing the first 2 points of error, which are, first, the 14th Amendment cannot be used against each other, and second, the use of race goes against the 14th Amendment itself. First, the statement of the facts. Section 1 of the 14th Amendment states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny the person within its jurisdiction the equal protection of laws. A 2008 graduate,
Counselor, does the language of the 14th Amendment support the notion of race-based affirmative action?
Well, Your Honor, stating that the 14th Amendment does not recognize any racial conscious acknowledgement in any way, because it is simply said for the equality of all people. And in our case, to give to one race and to take from one race and then to give to another just disproves the 14th Amendment and proves inequality.
Is it your assertion, Counselor, that taking without due process would be against the 14th Amendment?
Yes, Your Honor.
Okay, continue.
A 2008 graduate of Stephen F. Austin High School in Sugar Land, Texas, Abigail Fisher, applied to the University of Texas during her senior year. Fisher was the top 12% and had a GPA of 3.59 on a 4.0 scale. Plus, she even had an 1,180 SAT score. UT had adopted Texas HB 588 that allowed state universities to admit the top 10% of each high school graduating class automatically. 81% of the 2008 freshmen at UT entered under this top 10 rule. Because Fisher was not in the top 10 at Stephen F. High School, she had to apply through admissions and was later denied admissions in the University of Texas. The University of Texas had set up a new criteria after Grutter versus Bollinger, which included racial background as a factor. Fisher contended that because preference was given to the minority candidates, she was denied admissions to the school on the basis of her race, which was against the 14th Amendment. Addressing the first point, the 14th Amendment cannot go against itself. First, there is the 14th Amendment itself. The 14th Amendment, Section 1 states, all persons born, naturalized in the United States and subject to jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process, and nor deny any person within its jurisdiction the equal protection of the laws. In this process, college selection, if a college or university were going to use a race-conscious affirmative action consistent with the 14th Amendment to the United States Constitution, they would have to allow each person that was denied admission to the school full due process and allow them the ability to see exactly why they were denied. Without transparency and with race as part of the criteria, the appellee cannot claim that they acted in accordance with the 14th Amendment simply by excreting the statement without showing the exact due process as it shows every single person who has applied to the school. Compliance with the 14th Amendment is essential here because the University of Texas is a state-run institution of higher learning.
Counselor, getting back to the historical perspective here, could you tell me a little bit about the Freedmen's Bureau and how this post-Civil War program, does it provide support for affirmative action or not?
Well, Your Honor, addressing the Freedmen's Bureau, we can clearly see how this race-conscious program, which was enacted by the government, clearly did not work because it itself had denied the 14th Amendment of people as they tried to take from one race and give to another. However, we can see here that it is against the Constitution altogether.
Now, according to my recollection, Counselor, didn't Andrew Johnson, the President of the United States, veto an action like this, saying that you couldn't take from one and give to another without due process?
Yes, Your Honor.
Okay, now also on that same lines, is what we're trying to accomplish here with race conscious university admissions program. Is it trying to overdo the lingering effects of slavery in our modern society?
Well, the intentions were to integrate more racial. However, by doing so, they have denied the non-minorities, the majority of the people, the right to enter the college itself.
Council, that brings up an interesting question. Here in Texas, isn't Abigail Fisher a member of the minority?
With the growing populations of Hispanic students, she may be informally, however, it is not recognized as a minority yet.
You may continue.
By denying a person admissions without showing complete transparency is a violation of due process clause of the 14th Amendment. Second, the use of race goes against the 14th Amendment. The use of race as a qualification for admissions goes to the purpose of the 14th Amendment in the first place. This idea is taken from one group and giving to another group goes against the intent of the 14th Amendment. The 14th Amendment was outgrown of concern over the treatment of freed males by the Southern states. In 1864, during a debate on the enactment of the Freedmen's Bureau, Representative Thomas A. Hendricks, Democrat of Indiana, expressed these exact beliefs on the unconstitutionality of such legislation. He believed that the affirmative action measured in the Freedmen's Bureau legislation, particularly the taking of ex-Confederate land for the use of freedmen's education, was beyond that of Congress, was constitutionally capable of doing, and a violation of the separation of powers. According to the constitutional record, the Select Committee on Freedmen Affairs was established on December 6, 1865, with the mandate that so that the President's message as relates to freedmen shall be referred, and all report papers concerning freedmen shall be referred to them in the liberty of the report to the bill or otherwise.
Counselor, should we live in a society that's technically termed colorblind?
Yes, Your Honor.
Okay, in a colorblind society, would you have race-conscious university admissions programs like this?
No, Your Honor.
And what is the purpose of a college admissions office?
Is to admit the students into college, some of the best students, more qualified students, to join the ranks and as part of the college.
Okay, now the appellee is explained, University of Texas is explained that Abigail Fisher enrolled in, made application in 2008, but graduated from LSU in 2012. Now, does it, just because she's graduated, does that do anything to her standing in this court case, according to you?
No, Your Honor. Even though she may have graduated from another university, she still has power in this court.
Okay, now, is she representing just herself, or is she representing hundreds or thousands of other people in her same position?
She's representing not only herself, but also every person out there that could be in the same situation as her.
Okay, continue, please.
Thank you. At the opening of the second session of the same Congress, the committee was continued as a standing committee of the same jurisdiction. The Freedmen's Affairs Committee existed as a separate selective committee under the House Judiciary Committee until 1875. At the opening of the 44th Congress, Representative J.G. Blaine, Speaker of the House, observed that the recent amendments to the Constitution ensured that there is no longer any distinction between American citizens, that we are all equal under the law, and that all legislation respecting the rights of any person shall go through the regular standing committees. This is an essential argument that can be applied here. 89 years before the Civil Rights Act of 1964, the U.S. Congress noted that the special treatment of people should no longer go through a special committee, but it should go through an entire Congress. By noting this, I will be moving on to this. My partner will be moving on addressing the further 3 points. If there are no further questions, I will retire. Thank you.
Thank you.
Okay.
May it please the court, Your Honor. Please cross-apply my partner's comments, and I, Kevin Perez, will deliver the remainder of our arguments. Request resolved. We respectfully request that the lower court ruling shall be overturned. Resolution resolved, as my partner has stated, is race-conscious affirmative action consistent with the 14th Amendment to the United States Constitution? We answer with a no. Now we'll discuss the other 3 points of errors and give a summary of the facts as well. Summary of the facts, as my partner has went over them a little bit, I will just make it brief. Abigail Fisher went to Stephen F. Austin High School in Sugar Land, Texas, and graduated out of the top 13% of her class.
Counselor, how could this court evaluate race-conscious university admissions programs? And please kind of cite this to Bakke and Grutter, please.
Well, if we were to use Bakke, Grutter, Ricky versus Castano, and the parents involved in community schools case, let me start with the parents involved in community schools case. It states that schools may not use race as a determining factor to admission. This is a case that went all the way to the Supreme Court, stating that race is, in fact, a backstep from their purpose of the admissions in itself. Now, the admissions in itself, its policy is to provide the best prospects for the university or their current place of work. And in this case, it says that it was a backstep to use race as a admission tool for that.
So it's your assertion then that they would allow people that weren't qualified in just simply because of race, correct?
Correct.
Okay, give me about how Grutter applies here.
Okay, now Grutter in its ruling states that a law school case stating that race admission is okay. Now, in Grutter versus Bolliger, it states in itself that race admission is okay. However, this is in a law school program, a magnet school that does not apply here in court today, because we are talking about a college. We're talking about the University of Texas. And this law school in Grutter does not apply.
Okay, now University in Grutter, it was the University of Michigan Law School, and the University of Michigan Law School was 79% of the applicants were white, and Grutter was actually white. How does Abigail Fisher's case fit into this particular thing, where Abigail Fisher is one of only 26% of the people who graduate who are white in high school graduating class?
Now, Your Honor, these two cases, instead of being the same, it's actually varied, because under Grutter, the boy was part of the 79%, which you could argue is the majority. However, under sociology definition, minority is the lower part of the population. And since nowadays the population is growing, which has more Hispanic prospects, it's only logical that the minority must be the white men and women.
Okay, now in Bakke, the court ruled that the quota was not allowed. Are there any quotas at all in the Abigail Fisher case?
Quotas that are not allowed is why we're here today, which is the race admission. What is allowed is test scores and grades and history from the teachers. However, race cannot be used as an admission under California versus Bakke, because California versus Bakke was first ruled stating that race admission was okay, but later was reversed, stating that it forbade universities to take race as admission policy.
Counselor, also in the Bakke case, is very interesting because by the time it goes all the way through the court, the gentleman who wanted to get into the medical school was already approaching near 40 years old, which would make him too old to get in medical school. In this particular case, in Fisher's case, she's already graduated from college, which makes it kind of a moot point. How are those parallels related in this case?
Your Honor, the thing we can't call this case is moot. We could call Bakke moot because of the old age policy. However, in this case, even if she graduated from LSU, there is no policy that forbids a student to go to the university again after they have graduated. In fact, this counteracts against our opponent, because this in fact proves that this person is worthy of being in college, because she's already gone to LSU 4 years and graduated with outstanding numbers. So we see no reason why we should forbade Miss Fisher to go into the University of Texas.
Okay, with that in mind, has the University of Texas Austin shown that its race as admissions plus factor meets the strict scrutiny test?
Strict scrutiny test was in itself, it would have to provide a substantial reason for why they would use race admission. However, in itself, the purpose that the University of Texas has used, and many universities have used, was to in fact improve the diversity in the school, and in fact improve the school as itself in tradition and diversity and diffusion of
Counselor,
cultures.
to play devil's advocate here a moment, would you not say it would be to your advantage to have Abigail Fisher come into the University of Texas, because that would make the population more diverse, with her being Caucasian and the majority of the students graduating from Texas high schools being Hispanic?
Precisely. As I've said before, the minority nowadays is white, as white is reaching 30% at the most in the University of Texas as graduates. In fact, it's counterintuitive to try to forbade Ms. Fisher to go to the University of Texas if the true intentions of the UT of Austin is to diversify the races.
Okay, continue, please.
Okay, now moving on to point number 3, which is the purpose of admission office and selection. We answer with no, it is not adequate as of now. And what we mean by adequate is that them using race admission policy is not adequate to provide the best prospects and students for the following 3 reasons. First, the purpose is obviously to provide higher qualified candidates. When you're letting a woman who has scored a 1460 on her SAT and went to the top 13% of the class, you cannot let that go to waste. Next, race isn't a college talent that's needed. Race is not a factor that will determine whether someone graduates from college or not. At the end of the day, colleges, what their numbers are stacked on is graduation rates, not admission rates. Sure, admission rates are important, but graduation rates show that they are substantial enough as a university to bring a student for 4 years and to graduate with outstanding numbers. By them putting this policy, they're not fulfilling that purpose. And third, it's a red herring in itself. It is a wrong type of purpose or argument. The better argument should be we should provide with better qualified students who has better test scores, better percentage in their class instead of race. The University of Texas, respectable as it may seem that they are trying to diversify the races and make their college better, they should be more focused towards providing the best students. And even if they wanted the minority to join their school, well, there's no question the ethical official should be the UT of Austin right now.
Okay, now looking at legislation passed during the Reconstructive era, let's talk about a couple of these things. The Act of March the 3rd, 1865. Could you explain to me how that would actually pertain to this case?
Well, Your Honor, for the convenience of the court, I would actually like to do all of Act March 3rd, Act of July 16, and Act of July 24, 5 all at once. The reason why is because all 3 are connected with the Freedmen's Bureau, as my partner has stated. Act of March 3, 1865 is Freedmen's Bureau in itself. It has been signed in order to support blacks and give them food, shelter, etc. The Act of July 16, 1866 was to extend it for a period of time. However, Act of July 25, 1868 ended Freedmen's Bureau, and President Andrew Johnson himself vetoed the entire thing, stating that it didn't help at all, in fact, counterintuitive to what they had.
Okay, now what was Johnson's reasoning behind that rationale? Do you know, sir, Counselor?
Johnson's reasoning was, of course, many pages long, but the general point of his reasoning was that it, in fact, was it promoted inequality, and it promoted inequality because basically you're taking from one man and you're giving to another. The way how the Freedmen's Bureau was acted was from taking money, products, and everything from one man who was Caucasian to a black man. He stated that it was unfair and unequal. Therefore, Freedmen's Bureau was failed.
And also, Counselor, would it be without benefit of legal procedures as well, correct?
It is not a benefit to legal procedures at all.
Okay. Could you discuss some of the discussion in the 38th Congress, the first session of 1865, the Congressional Globe, please?
Congressional Globe. Actually, Your Honor, I may ask of the court to allow me to talk about 30th Congress first session, 39th and 44th Congress. 30th Congress states a debate about equality. Now, in this debate about equality, one quote that stands out for most, which decided the turn of this debate, was that mankind is equal, quoted from one of the debaters. Now, with this quote and what this debate was about is whether or not we should provide, it was tied to Freedmen's Bureau, but it was more about whether or not we should weigh helping the minority or working towards equality, which the debate turned out to say that mankind is equal, therefore we should support them equally as man. Because under the definition of the man who quoted this, it's quite clear that he wanted a colorblind nation. As my partner has stated, a colorblind nation is the best nation, and such as that, a colorblind university and colorblind admission policy is also required.
Okay, and by colorblind here, you would mean no preferences to any color, correct?
Precisely.
Okay, and
now that we've gone through that, we pray that you overturn the lower court's ruling and that you find the resolution negative in the favor of our side. Thank you.